One of the biggest issues in workers' compensation cases is how to get medical approval for the treatment that you need. It's a pretty complicated situation, and one that myself and my team spend quite a bit of time trying to help our clients with. The first step is that the medical provider has to request permission from a utilization review carrier. Utilization review is a simple way of explaining that a medical provider hired by the insurer has to say that the treatment being recommended by the doctor is reasonable and necessary given the diagnosis. If the utilization review provider says that the treatment is reasonable and necessary, that's the first step for the approval. The second step, equally as important, is that the claims adjuster then has to say whether or not they feel that that treatment is related to the industrial injury for which the insurer is paying benefits. So if utilization review says yes, but the adjuster says, I don't think this is my responsibility because I don't think this is related to the injury, then they get to say no. And if the insurer says no, then the answer is no, at least temporarily. Then a claim has to be filed with the Department of Industrial Accidents, and we go in front of an administrative judge who decides whether or not the treatment should be paid for by the insurer. The other issue that comes up is when utilization review says no. If they say that the treatment being requested is not reasonable and necessary, then they say no and it doesn't even get to the adjuster. If the utilization review answer is no, then the answer has to be appealed. The denial has to be appealed by either the doctor or the patient. Ordinarily, we recommend that the doctor appeal it because when it's appealed, the utilization review carrier has what's called a peer-to-peer review with the medical provider. So somebody from utilization review calls the doctor and talks to that doctor about what they want and why they think it's appropriate. Then utilization review makes a second determination. If the denial is reversed and utilization review says yes, then it goes to the adjuster and the adjuster decides. If utilization review says no a second time, then your next step is to file a claim with the Department of Industrial Accidents, go in front of an administrative judge, and have the judge decide. So as you can tell, both of these components can be very complicated for the injured worker, but not so complicated for me and my team.